1 second to retrieve a pen. Yes.
Just to finish the point on control of custody and the reasoning in Rahmatullah and why it was that they found that there was de facto control over custody in that case. I referred you earlier on to the Lord Atkinson quote from O'Brien.
Yes.
If you go in tab 12 in Rahmatullah, back to paragraph 47 of Lord Kerr's judgment, you will see that passage from Lord Atkinson cited. And the essence of it, it might be thought, is in the final sentence of the quote. So paragraph 47 of Lord Kerr, quoting Lord Atkinson.
Sorry, and which paragraph of Lord Kerr? 47, you said.
Yeah,
sorry.
47.
Yep.
Quoting Lord Atkinson. I'm trying to show you the reasoning for why they concluded de facto control. And the answer appeared to be because, A, there were the arrangements, and it would be a bit unfair, as Lord Atkinson rather mildly put it, to assume that someone who'd entered into that sort of arrangement wouldn't comply with it. So it's pretty obvious. But that's at the heart of Lord Kerr's reasoning. And then Lord Reid, I referred you to earlier on, that's the passage between D and E on page 457 within 112, so 112 of Lord Reid, between D and E, on its face, that agreement gave the Secretaries of State de facto control over the detention on the reasonable assumption. Yeah, that's the Atkinson point again, the Lord Atkinson point. And then going forward into Lord Conworth and Baroness Hale, you see at 118, first sentence, on the issue of control, the effect of the two MOUs is crucial. 119, first sentence, as you see, clause 4 is central because on the evidence it was designed specifically to ensure that the UK did retain control over the continuing legality of the detention. You see, over the legality of the detention and so on. And then if you go into 122, you will see between E and F, closer to F, last sentence of that paragraph, it rests on a much stronger basis that the UK was the original detaining power, that as such it had continuing responsibilities under GC4, and that it entered into an agreement with the USA giving it the necessary control for that purpose.
Yes.
So a conclusion is de facto control. They weren't troubled by whether or not it was technically legally enforceable, but it was the combination of GC4 and the agreements, and as my lord pointed out before the short adjournment, those agreements flowed from the fact, and wouldn't have existed but for the fact, of initial detention by the UK, followed by the transfer pursuant to those arrangements. So that's the second broad point. The third broad point that we make is that the claimant's approach we submit divorces the remedy from its principal grounding, which is to require that the person detaining or having actual control, de jure or de facto, must justify the legality of its conduct. That's the purpose of the writ. And that, no doubt, is why, in all of these cases, some UK unlawfulness is a key feature, including in Rahmatullah. And just to go back very briefly, keep a finger in tab 12 notionally, but if you go back briefly to Mr. Justice Elias in Sanko, behind tab 5, can I just invite you to read on page 183, paragraphs 36 to 39. To some extent, this is the unexplored issue territory that you'll recall from Rahmatullah. And of course, usually it is the UK government or the person who detains in the United Kingdom justifying as lawful or not the detention. But Rahmatullah goes a little bit further, but is assiduous in the Supreme Court to explain why the limited extension to cover UK unlawfulness in effect by inaction was enough. And if you go back into tab 12...
Sorry, I think I'm being slow here, but just get me back on track. The purpose of the writ is to get the current detainer into court to justify the lawfulness of the detention. In a Rahmatullah case, the UK is the detainer because it had entered into an agreement under which it had the power to call for the transfer back at any time.
Yeah.
And I don't quite understand the point about there being any UK unlawfulness.
Well, my lord...
They would have, because they were the detainer, they would have to say, in a way which satisfied an English court, why they were detaining.
Why who were detaining?
They, the UK, through the US.
Well, yes, but that therein lies quite an interesting and difficult question, potentially. Would they have to have said, well, we are, as it were, in de facto control because we have the obligations under the MOU and all the rest of it, so all we have to justify is what we're doing under those? Or would they have had to have said, no, well, the UK are the actual detainers, so the actual basis for the detention under US law or international law or whatever it is X, Y, Z. And it looks as though, it's not finally resolved, but it looks as though the Supreme Court were focusing much more closely on the UK's potential unlawfulness. Can I just, it may be easier if I take you to paragraph 53 of Lord Kerr.
Well, it always will. Yes, okay, right. Yes, take me to paragraph 53.
So he says in the first sentence, there's clear prima facie evidence in the present case that Mr. Rahmatullah is unlawfully detained. That appeared to be a reference to the fact that the US were continuing to hold him after the end of hostilities and outside the territory in which the hostilities had happened. But then if you go on and you look by the letter F, he's concerned to point out that the illegality in this case, I'm reading from the sentence just by the letter F within paragraph 53, the illegality in this case centres on the UK's obligations under the Geneva Conventions. So the UK's obligations, it does not require the court to examine whether the US is in breach of its international obligations. And then drop down to the final sentence. The illegality rests not on whether the US was in breach of GC4, but on the proposition that, conscious of those apparent violations, the UK was bound to take steps.
Yes.
The steps required by Article 45. Yeah. Sorry, we may be at cross purposes, but the point I'm simply emphasising is that in this way, he avoided, or the Supreme Court, as it were, avoid the problem that potentially might arise under foreign act of state, for one thing, of opining on the legality of the detention by another sovereign state, friendly sovereign state. And the focus for habeas purposes, albeit because they concluded the UK was in control of the custody in the manner they described, the focus here would have been on the UK's unlawfulness, and it was through that mechanism and through that analysis that Lord Kerr was able to say, well, so for that reason we don't need to trouble about whether or not we're in territory where we're opining on the legality of the US detention. So it's all about UK unlawfulness in their inaction, bound to take steps required. That's the only point I make. And then he comes back to it at paragraph 70, which I referred you, I think, to earlier, but page 630 or 643 in the internal page numbers, but paragraph 70, for reasons that I've given at 38, 40 and 53, the legality of the US's detention of Rahmatullah is not under scrutiny here. It's the lawfulness of the UK's inaction in seeking his return that is an issue.
Yes, in seeking his return from a
friendly foreign state.
It's a little bit of a sleight of hand because what has generated the requirement to return is the fact that the UK should have thought that there was a breach. Anyway.
And there's a bit of prima facie unlawfulness at the beginning of paragraph 53 because he couldn't help himself, if I'm allowed to put it in that way without disrespect. But yes, I think my lord is right. But my point is the rather narrow one, which is that there's always a focus on UK illegality and what does that involve. But you get the same point in O'Brien. It's the same idea. But in every case, you get into that territory with that potential focus of the illegality issue, with all the sensitivities of ruling on the illegality by the foreign state itself, or whatever it may be. You get into that position.
Well, why does all this matter to you, Mr. James, in the circumstances of our present case?
Because it's to emphasise the difference between our sort of context and Rahmatullah. The only reason you get into that context and that set of issues in Rahmatullah, with that need to justify and to feather, is because the UK has made itself legally responsible, in effect, for the detention. And because that then conforms to the essence of the writ, which is to require an explanation of the lawfulness of the UK's actions. In none of these cases do they say, well, we're going to examine whether it's competent to the Irish Free State to keep detaining O'Brien, or it's competent to look at whether or not the US was detaining lawfully. It's always about the UK position, and the UK position is of interest in those cases precisely because it's created the circumstances that you see there described, which is not either us or anything like us. And it may be that that's why there was at least the open question identified, the unresolved questions that you see reflected in Lord Reid paragraph 115 and Lord Phillips 106 to 107, because they were, I suspect, a little more doubtful about the Lord Kerr analysis that we've just seen in 53, maybe because of at least a potential for thinking that it might be a sleight of hand. But that then takes one, finally on this point, that takes one to the point that I know my Lord is very well aware of anyway, which is why it was that Lord Carnwath and the Baroness were unconcerned about the unexplored issue. And you see that at 121 and in particular 122, where they explain why they think that it doesn't arise. The unexplored issue doesn't arise on the facts of the case. Fourthly, again, it's a point that you already have, so I'll make it shortly. The fact of initial detention and the subsequent question as to whether or not control has been relinquished, as my lady pointed out, has also been treated as one of the critical indicators or features in cases where control has been found. In every one of the cases in which the writ has ever run, the UK has detained at some point. And you can't divorce the statements about the criticality of reasonable grounds for believing that you could get control back, whether in O'Brien or in Rahmatullah, from the key features that led to the issue of the writ. And you will have noted, it won't, I'm sure, have escaped you, that both 53 in Rahmatullah, para 53 in Rahmatullah, and para 64 reasonable grounds, as it's put in the first sentence of para 64, reasonable grounds on which it may be concluded that the respondent will be able to assert that control. You will see that they're all under the section entitled Control that starts above paragraph 45 in the judgment of Lord Kerr. So it was the combination of initial detention by the UK, transfer, arrangements for return, all of that was both sufficient and necessary.
Why and necessary? Is there something in one of the judgments which says that?
Well, necessary, my lord, because without that you wouldn't have had the ability to exercise the degree of control that the MOUs and the arrangements provided.
Those were the facts of the case.
They were.
And in all of these cases, if I may say so, perhaps I was missing something in your third and fourth points, but the conduct of the UK is an issue because that's the respondent.
Yes.
That was the person who was said to be liable to, or the body that was said to be liable to produce the body and justify detention. So speaking for myself, I don't really see how that helps to define the ambit of control.
Well, my lord, my point is, my purpose is perhaps a more the negative one of meeting the case that says it is enough that you could request.
Yes, I understand that, and I perfectly understand the proposition that what the appellants seek would seem to go quite far beyond what previous courts have decided. But
my lord, that's
I
my
just want
limited
merely to
purpose.
look at the facts of the case and say, well, in that case, that was sufficient, is fine. But to add and necessary, speaking for myself, I'd want a bit more.
Well, my lord, I think I don't wish to seek to elevate this into a jurisdictional precondition, because you know that we put the case, as it were, rather more loosely in agreement with the Divisional Court as they recorded. But the real reason for saying "and necessary" is "and necessary on the facts," because it then led to. I mean, that doesn't elevate it in the way that my lord has put to me.
It's a neat answer, if I say so.
But if it helps, I'm not elevating it to a jurisdictional precondition.
All right.
I'm simply pointing out that it was of the essence of Ramatullah. If you're saying, well, Ramatullah said de facto control, that means it's all a question of fact. So if you can ask and they will give, that's enough. My answer is no, it isn't, because Ramatullah turned, as is entirely obvious from the reasoning of all of the judges, it turned on that combination, and including in particular the nature of the arrangements which gave the UK the right to call for the body back, to reassert that control.
I mean, why aren't you saying it's a jurisdictional, prior detention is a jurisdictional precondition? In this sense, what I think is inherent in all your submissions, and there's obviously some support for it in the case law, is that habeas corpus is about the circumstance in which I'll leave out private habeas for the moment, but a public authority has taken someone into custody. And if that person has never done that, I require some convincing that it's within the scope of habeas corpus at all.
Well, one could go that far. The only reason I'm a bit nervous about, and I don't need to go that far, is one answer. But the second answer of principle is I'm a little bit nervous about going that far, because it may be possible, at least theoretically, to envisage circumstances in which you, as it were, acquire the requisite control through some form of some set of arrangements, as it were.
Yes, perhaps, but if by prior detention one means original detention, then I agree with you. But at some point, I would have thought you had to have either continued or brought about the detention, even if you then, which gives rise to the Ramatullah type problems, transfer the custody to someone else. So I certainly wouldn't say you must be the original detainer, but you must at some point have been a detainer
properly so called.
Or perhaps your agent
Yes.
has done the detaining for you, but
Yes.
in circumstances where it's clearly your agent.
My lord, I respectfully agree with that. It was just
and that might, of course, the American authorities might extend
exactly.
that.
yes.
But again, in a way that you can understand. I mean, Whether we would do it ourselves, I don't know. But
Yes.
you can see if you actually have got the Saudi authorities to detain someone, quotes for you, whatever the legalities of their doing so, that's not really outside the spirit of what we're discussing.
Right.
Sorry, I'm
It
thinking
would
loud,
require
which isn't very
something,
helpful.
even in that situation, it would require something pretty strong.
Well, I dare say.
If the suggestion on the back of the American case, which I should at least put down the marker on, if the suggestion on the back of the American case is the broader one that says if you provide, for example, intelligence to a friendly foreign power and they go off and
I don't
detain
think you
someone.
need to worry about that.
No.
Ms. Taufman wasn't putting it
But
that
my
high.
lord, I entirely take the point. My only reservation or worry was with the original detention.
Yes, I see.
Well, there's a fifth point, is that the consequences of the claimant's approach are, we respectfully submit, or would be, both surprising and unacceptably uncontrolled. They essentially say, if you can, in fact, produce the body, as it were, that is the test. But the implication of the submissions, and subject to the climb down that happened this morning, or the attempted climb down that happened this morning, which I'll deal with in a second, the logic of that position was, of course, if it's a pure factual question, that the imposition of conditions by the detainer and the compliance with those conditions would simply become a matter of obligation. And at that stage, we respectfully submit, the argument becomes obviously unworkable and obviously absurd. And it becomes that because one can posit a whole series of different conditions, or perhaps even steps, even if you don't have conditions, that would render that argument extremely problematic. One can take the hostage situation from £10 to 100 million without affecting its essence. But the answer, yes, and I apologise profusely for the guffaw yesterday when the answer yes came out, but the answer yes to that question is intensely problematic. One can posit different examples. Suppose, for the sake of argument, that someone said, well, you can have them, but you've got to come to the camp to pick them up. And in order to get to the camp, you've got to cross 150 miles of terrifyingly insecure and dangerous country. And once one gets to that stage and the examples start multiplying, it does become very, very difficult. Do you have to use up diplomatic goodwill to extract people? Do you have to do that and take all of those steps and subject people to risk in securing return in relation not merely, for example, to unaccompanied minors? And I should say at this point that those who come out of the camps who've been related to the UK or UK nationals have to date, as I understand it, been solely unaccompanied children, with one exception, a week or two before the hearing, when a mother came out with a child. But do you have to do it not only for them, but do you have to also do it for people who you regard as being a potential threat to your national security? Do you have to expose the consular staff to the risk of crossing 500 miles of bandit country? Or do you have to pay the £10 million or whatever it may be? And the difficulty is that what that illustrates is not merely the intense problem of that relates back to control, but they illustrate that you can't possibly proceed on the basis that whatever the obstacles are, whatever the steps are that have to be taken, whatever the conditions may be, they simply become matters of obligation because they are essential to the return. And the argument did appear to be that. The argument did appear to be, well, once you get to the place in which you've got control, defined in the way my learned friend identified, you then have an obligation to do everything that is necessary to bring the body back to the country. But that is, we respectfully submit, extremely difficult for all of the reasons that I'm indicating, including that it removes all the judgments that are inherent in whether or not you should take those steps in those sorts of situations. So my learned friend then came back this morning and said, well, no, when I said yes, I meant no in relation to the hostage situation. But the difficulty with that attempt to come back to a more acceptable place case in relation to the hostage example is that it doesn't really help her. If the fulfilment of the condition is the thing that is needed to gain the requisite control or to bring the body back, then it all becomes circular. The practical problem is that any condition that needs to be satisfied prior to release, or in her case return to the United Kingdom, or any step that would need to be taken, simply becomes a matter of obligation, and it can't make any difference once one reaches that point, whether it's £10, £10 million, £100 million, or 500 miles of bandit country.
Or another example occurred to me over lunch. If I'm remembering my history correctly, I seem to remember that President Amin, when he was unlawfully arrested a British national, and said, I will hand him over, but only if the Home Secretary comes to
say frightfully sorry in person and grovel.
And grovel.
Yeah.
Which indeed the Home Secretary did. But I wonder whether that would, when you said expenditure of diplomatic capital, that might be another example.
My lord, it might. But my point is with the logic of the attempt to come down from that really difficult place. Once you're into the turf of saying, whatever the steps are, once you've got de facto control because they're going to release if you say yes, doesn't matter what the conditions are, doesn't matter what the steps are, it can't then turn as a matter of logic on how bad or how good the steps are. And it can't turn on that for obvious absurdity reason, but it also can't turn on that for good constitutional reason, which is that's what I meant by, when I said earlier, constitutional location of the decision making. Because whether or not to take the step, whether or not to grovel to Idi Amin or to cross the country or pay £10 million is a matter of judgment. You might choose to do it for an unaccompanied child in extreme circumstances. You might not choose to do it in someone who's an adult who presents a national security risk. But it illustrates the point that these are all judgments that would need to be taken. I should just divert a little bit at that point in relation to Rahmatullah and what would have happened. There was quite an interesting debate about what would have happened in Rahmatullah, but without revealing any in-house secrets, as it were, in Rahmatullah, stage one, as you will recall, was, did we have to write a letter to the Americans to say, we've been told by the courts to give, to see whether we can secure the release pursuant to these arrangements, kindly release secure to these arrangements. And the answer that came back was, not quite enforced and not yet, but it was no, perhaps in the future at some point, but not yet. But it was the no. That was the subject of the cross appeal and all of the debate that happened there. What would have happened is a much more difficult and open question. I mean, suppose the Americans had said yes. I can't remember precisely where the individual was held, I think in Afghanistan, say. So suppose the individual is held in Kabul, and the answer is, yes, we are prepared to release him. He's a Pakistani national. Right? So at that point, there would have been a question. Would the force of the writ, and I don't think the wording of the writ was changed, but my recollection may be faulty. I think the writ was issued in standard form and the letter was sent, as it were. What would have happened if the Americans had said, yes, we're prepared to release him to you in Kabul? Now, at that point, we would have had on our hands a mono-national who was a Pakistani, had no connection with the United Kingdom, as I recall, certainly wasn't a British national, and we'd have had him in Kabul. Now, there would then have been all sorts of difficult questions, no doubt, including the one that my Lord Justice Holroyde raised, which is, what is the relationship at that point when you're in Kabul, you're the British official, and you have Mr. Rahmatullah by the collar, as it were. It may be difficult to find a power to detain, even more difficult to find a power to deport as a British official from Kabul to Pakistan, which was the only country that he was a national of. And so there would have been a question as to precisely how that would have been managed. Now, no doubt, in ordinary diplomatic ways, it would have been managed by the Americans flying him back to Pakistan, which I think in the end was what happened. But it doesn't solve the difficulties and the technical problems that would have arisen. The point I wanted to bring home was, it does not necessarily follow from the facts of Rahmatullah that if the Americans had said yes, that individual would have had to have been brought back to the High Court in London, when he would have claimed asylum and would have gone through years.
Well, no, and indeed that would have been because although, as Kaufman said, of course, the obligation to bring back or to repatriate doesn't only arise from the conditions imposed by AANES, which we'd be duty-bound, morally bound to follow if we accepted their offer. The writ itself requires them to be repatriated. That's actually not quite right, is it?
It isn't.
The writ, the object to bring someone to court is only if you're seeking to justify the release, justify the continued detention. There may be another reason as well, but if logically you, who ex hypothesi are in law the detainer, get back your actual custody and at once relinquish it, so you're released now, so there's nothing for the court to determine. There might be a claim for damages for unlawful, but there's no habeas corpus reason for you. You don't have to bring him back to England.
We turn up we turn up in the High Court and we say he was released to us by the Americans in Kabul, and we released him. We had no basis for detaining him further. You don't have
the same would be true in this case, wouldn't it? That as far as habeas corpus was concerned, there may be other problems. If you did go to a camp and well, it might be, I don't know how they do it, it may actually be at a transit point at the nearest border, doesn't matter, but you go back to the nearest border, you take her across the border and then say, right, we've achieved your release.
So you wouldn't even have to take them across the border. Take her across
no, all right, but I'm just trying to avoid...
yes.
I think it may well be that AANES don't really mind whether she's repatriated. They just don't want her released in northern Syria.
Into the arena of northern Syria.
So, but ignore exactly what you said to them, just taking the Starch case where they haven't attached that condition. You achieve the release and release her anywhere other than the UK, you would have achieved your habeas obligations because you would have released her from detention.
Well, that
you might have other obligations to bring her back, which we would like to explore with you later. But that's where habeas has done its job, isn't it?
Yes, but you might or might not do. What that illustrates, if I may respectfully say so, or so submit, what that illustrates is that there are then additional decisions and questions that would have to be made as to whether or not to take them across the border or not take them across the border.
Well, you could take them across the border and say, I wish to retain you in custody. Quite what form that would take.
You could or you couldn't.
You could. It would be open to you to say, I want you to remain detained, but I've got to bring you to the UK.
So what the basis for the detention would be, that's the trouble.
To establish, well, I think there would be a difficulty about it, but assuming you might came to the UK and then find that you hadn't, by the time you got to the UK, you might have a basis for detention.
Well, you might do, and you might be facing a claim for unlawful detention on the journey.
Yeah, exactly, you might. You might. But it we're not just playing games here. I'm just trying to work out.
We're not.
The capacity in which you're acting at any stage.
But my core point for present purposes is that what this debate illustrates is that there are a set of decisions and a set of steps that will have to be taken that you can't avoid simply by turning up and saying it's habeas, so you're under an obligation to bring me back to the United Kingdom. And indeed, it might be thought that on the logic of my learned friend's argument, even in its attenuated form, the logic would apply it isn't a nationality-based argument. It applies, and the logic would apply on her case, on habeas, on its reach, and when it will run and when it won't run. It would apply to nationals and non-nationals. And in relation to non-nationals, as it said, well, there's an obligation to bring them back to the UK, and so on. Well, the answer to that, it can't be right, because if you're released pursuant to the force of habeas and you're a non-national, that cannot confer on you the right to enter the United Kingdom. That's just a totally separate set of issues. Hence the attempt to explore what would have happened if the Americans had said yes in Mamatola.
Logically, it is British national and therefore but on this particular occasion wants to come back to the UK, it's to some extent adventitious that one way of doing it is to be brought back pursuant to the writ.
So there are much broader consequences, but in principle, you've still got, whether it's a British national and you've got to do the series of steps to the consular official, go across the country and pick her up and bring her back, exhaust the diplomatic capital, take her to the embassy and fly her back, or the steps and the decision making that would have to happen if they're a non-national. In both scenarios, there are those additional judgments that have to be made, balances that have to be struck. And the whole flaw in this application is that my learned friend seeks to just bypass all of that, sweep it all away on the back and on the force of Ramatullah, which was fundamentally different for all the reasons I gave, by saying, no, habeas control, don't need to bother about the Ramatullah.
Could we perhaps, while we're on this,
Yes.
maybe something you can come to later, in which case tell me and I'll stop. It's inherent in your whole submission on this that these issues are issues which could, in principle, be explored in judicial review proceedings. You might say they would face all sorts of difficulties, I'm sure you would, but nevertheless, the kinds of decisions, is it right to have to incur all the expenditure of effort, money, perhaps some risk?
In principle, yes.
And the court could, in principle, say, that you say they should be very slow to say it, yes, we think it is right. You've got to do it. But all that would be a different kind of case. While I'm on that, do I understand you to be saying that you could, in principle, say that we are not obliged. Just suppose it wasn't, there weren't all those risks. Suppose she was in an ordinary civil prison in a reasonably safe part of the country. It wasn't a great problem to get her released. You only had to say, yes, we want her. And she's then let out the door. They don't require the British consul to attend. That you can reasonably say, well, find your own way to the consulate.
Well, as a matter of governmental decision making,
Yes.
rather than habeas running. As a matter of governmental decision making, you'd have to make a judgment. No doubt you'd have to weigh a whole bunch of different considerations, and it may well be that in that situation, taking that purely as a hypothetical set of facts, in that situation, no doubt you would want to weigh whether she was with a child, how far it was,
Right.
and whether or not you wanted to make any effort in her case because the humanitarian pull outweighed other things that might operate against that. E.g., do you really want to assist someone to come back to the United Kingdom if they are a national security threat? But those matters, to go back to your fundamental question, those matters are matters which are properly for government to weigh. And of course, when they've done that weighing and have reached a decision, the decision as a governmental decision is amenable to judicial review. The basis on which the judicial review would happen is a different question, because that would bring in all the principles from Al-Rawi and Abbasi about forbidden territory and how much leeway you give them.
No.
But in principle, yes, my lord, I should, just so I don't have to go back to it, finish this this discussion about, not at all, this discussion about judicial review, which is helpful because it illustrates the point I made before the short adjournment. But there is a procedural aspect to this, which is that with a bit of prompting from my lord, my learned friend sought to leap onto the bandwagon that says remit it back so it becomes a judicial review. And of course, in relation to that, you will no doubt need to think about two things perhaps. The first of them is that it isn't a good reason for sending it back to become a judicial review that you might or might not be considering expanding the boundaries of habeas.
No, quite.
If you're going to expand the boundaries of habeas, you do it on a habeas application.
No, well, that I understand.
And the second thing to bear in mind is a procedural point, which is that the High Court, as I understand it, has power under, I think it's Order 87, Rule 4.1d. The High Court has power to convert, as it were, a habeas application into a judicial review. That isn't a power which is available to the Court of Appeal, it isn't a course which was sought or applied for in this case at all. And perhaps the third thing to bear in mind is that even if that application were to be made, you would have to go through the proper JR processes. You'd have to identify what the grounds for a judicial review were, what decision is it that you're challenging, on what public law basis are you challenging that set of grounds, do you then pass the permission hurdle, and the difficulty that my learned friend would face, which is no doubt the reason why they didn't pursue this in the High Court as a possibility, is that the moment you get into that territory, you are dealing with public law challenges to government judgments. And that is not what they want at all. What they want is light touch control followed by obligation. But that's all I wanted to say about.
Yes,
have I remembered the provision?
Any indication we would go down this route, but since it's been suggested, can we just quickly look at 87?
Yeah. Is it? Did I say 4-1?
I think it's 87.
87.5D and 87.4.1D.
Yes, I see. Well, we'll look at this in detail if we have to. I ought to know this, but if the High Court has power to do it, there's a catch-all provision somewhere, isn't there, that on appeal, the Court of Appeal can do anything that the High Court could have done? Sure there is.
Somewhere in Order 52. I mean, Part 52.
Part 52.
Part 52 is it? Maybe you could. But the short point is, although the High Court technically would have had that power, no invitation was made to them to issue it, and you're sitting as a Court of Appeal from that decision.
No, but I understand your substantive rather than purely technical point to be, if you're going to do that in a case which hasn't been formulated thus far on judicial review basis, it would have to be reformulated effectively from scratch. No real advantage in remitting. Start again with proper pleadings and so on.
Yeah. And then you may have to cross all the bridges that judicial review
may
makes
have to
you
get permission. Yeah.
cross, permission, time, all of that.
I think the rule my lord was thinking of is Part 52.21. In relation to an appeal, the appeal court has all the powers of the lower court, subject to.
Right. Well, thank you. I'm great.
Yes,
That is indeed what I had in mind.
Thank you.
But yes, well, it's been a slight digression, though, one we had to do at some point, so we've now done it.
I was still on the fifth point, which is the consequences were surprising and unacceptably uncontrolled. And that's how we got into this debate about ransoms and crossing the country and all of that.
Yeah.
But you will also appreciate, and again, I've touched this argument already, so I can just make it again so you have it in your note, but no more. I mean, it would be a very, very wide impact if my learned friend's conception of when habeas runs is right. You would sweep away all judgment and replace it with an obligation based on an uncontrolled can. And I've touched on the point already, but why that logic wouldn't apply, we respectfully submit it would, but it's just simply unaddressed, would apply to British national, all British nationals currently detained in Syria in this way, and indeed anyone else, a person who resided here, why not on that logic?
Person who what, sorry?
A person who resided in the UK at any point, even if they're not a national. I mean, there would be all sorts of issues and questions about the breadth of it, including intervention in a wide range of circumstances in relation to people who happen to be detained around the world, depending on just how far the can test goes. And it would mean, which is no doubt why the courts are at least concerned about keeping a weather eye on this issue, it would mean, if you stretch it too far that way, that you run into the difficult territory that we identified by reference to Rahmatullah, which is, what is it that you're justifying on the return? Well, it's easy to say you're justifying the legality of the detention, but what does that mean? Does that mean, per Rahmatullah, UK inaction, which the Supreme Court, Lord Kerr, were determined to say that's what it did mean, because he realised that if he didn't say that, he was going to be in trouble on the Abbasid line of authority, C104 of Lord Philip's judgment in that case. Or does it mean that you have to justify the detention, which appears to be what's envisaged here, by reference to, as it were, a foreign system or systems of law? I mean, what's it going to be when you're dealing with a non-state actor, where you're dealing with detention in a non-international armed conflict and
But
all
in
of that?
practice, in habeas corpus, you're always, if you get to that point where the body's in front of the court, you are justifying the detention at that moment, why you shouldn't release them then. It's not a false imprisonment jurisdiction.
It isn't. That's true.
So, if she were to be brought back and brought to court under a writ, the real question then would then, I imagine, be, should they be detained in the UK? Or I suppose, should she be, nobody can suggest she should be returned to, UK won't be seeking to justify the detention, a return to detention in northeast Syria.
I don't know. I don't know what the case is against me on that. But there is a...
No, but
there is
conceptually, am I not right? Conceptually, you're saying to the court, I need to continue detaining this person because... Isn't that what happens?
Or you say to the court, I've tried and I don't control them. I've
Oh,
tried
well,
to
yes, so
exercise
you say
them.
that, or you might say, well, it's all dead because I've released them in the meantime.
Yes, but supposing you say there is control enough, because you can ask and they would give, subject to conditions, but that's a matter of obligation, just bring them back. There is then a question about what you do when the person gets here.
Well,
I suppose you say, well, at that point, we haven't got any ability to detain them in London.
yes, well, you might say that.
Or on
Or
the
you might
streets
say
of,
in the meantime, you might have found some power to detain them. But I mean,
or on the streets of northeast Syria.
So you might be in a position where the writ gives you an authority to detain someone whom you wouldn't otherwise have authority to detain in order to bring them in front of the court.
Yeah, which it feels a bit roundabout.
Yeah.
But there is at least a potential problem which you can see the Supreme Court grappling with, which is at some point, and you may be right, you may be able to circumvent it and you ask the present question and you avoid it by that route, but the Supreme Court were obviously very worried in Rahmatullah, for foreign act of state reasons no doubt amongst others, to say we are not doing the legality of the American detention. we are simply doing UK inaction, UK failure to seek.
I mean, this is an entire problem about foreign detention.
Yes.
Because, classic vanilla habeas corpus, the jail is down the road, the jailer comes with the person.
Here's my warrant.
Here's my warrant, but the point is, the jailer never releases, but they come in, as it were, in handcuffs from the jail to the RCJ, and if the warrant is accepted, they're sent back again, and if it isn't, the handcuffs are struck off and you can go.
Maybe it's no more complicated than urging caution in those cases, because those sorts of issues are extremely difficult. Quite how you would go about justifying it, how it would work in practice.
Well, as my Lord's question, I think earlier, what would the status,
of the relationship be?
If the consular officer, from the moment that they're released from and put into the British Army vehicle or the British consular vehicle, would he have any power to detain?
Well,
Might not arise in practice because she's anxious to stay with the British consulate to get to the airport.
Extreme, no doubt, but they get to the first crossroads and they're waiting, guns are toting, is a pickup truck that says, she says, those are my mates, I want to get out.
But James, going back to my status point, which my Lord has just mentioned, it does strike me that one of the unusual features of the the situation with the foreign jurisdiction is that, as my lord has just said, in the conventional habeas, the jailer has brought the detained person to court and is seeking to justify detention.
Yes.
We're now contemplating a situation where, if asked, well, why are you detaining this person, the consular official would say, well, I'm not really. I've just been told to bring them here, but I don't want to detain them.
Yeah.
And if then asked, well, why were you detaining them in Syria?
I wasn't.
Say, well, I wasn't detaining them in Syria. It's an unusual situation.
It's an unusual situation, but it does rather emphasise, or at least it potentially emphasises, the wisdom of the primary principle, which was my second one, which is, are you in control of the custody? And the moment you interpose steps and those sorts of difficulties, then you end up in constitutionally difficult territory, practically difficult territory, and difficulties of the sort you just indicated. I respectfully agree. My Lord, my sixth point, again, I've made, and I can make it very quickly, we've touched on it already, which is that the limits of habeas, precisely because it is a remedy as of right, with correlative obligations, should respect and do respect the constitutional boundaries that we've been discussing. And the courts are always assiduous to avoid the risks of cutting into decision-making and judgments that are properly the province of the executive. National security, see Supreme Court in Begum, foreign relations, and so on. And you have all of the relevant authorities, Begum, Raymond, Al-Rawi, Abbasi, if you want, on those self-evident propositions. I'm not going to trawl through all those again. You saw and will recall Lord Justice Law was citing them in the Sanko decision at paragraph 9 in the Court of Appeal, or at least referring obliquely to some of them. And I do respectfully submit that they are important, and the fact that they are important is not in any way dissented from or undermined by the way the Supreme Court analysed Rahmatullah. Indeed, the speech of Lord Kerr went out of its way to acknowledge those principles, but to conclude on the facts that they were not engaged. Now, again, you might think that involves something of a sleight of hand, but that was the reasoning, and that was the reasoning is clear from the judgment of Lord Kerr, where he doesn't say, well, these aren't of interest. He just says, this doesn't apply here. And the reason he seemed to say that, I think, was because of back to the MOUs and the arrangements. He said, all you have to do is to ask them to do that which they've agreed to do already, on the reasonable assumption per Lord Atkinson that they will comply. So he says it doesn't arise. You don't have to make any kind of diplomatic judgments. You just have to ask the question, and there is the obligation. It might be thought that the return, when we did ask the question, rather undercut that reasoning on the facts, but that was the reasoning. So, my Lord, for all of those...
Sorry, can I just ask one question that's just been occurring to me?
Yeah.
Mwenya was all at a very preliminary stage. Was there any discussion, it's a very long judgment, of what would have happened if the writ had issued, which in the end it didn't? Would Mr. Mwenya have had to be brought all the way to the Strand? Presumably he would.
Well,
and they might have done a deal under which he wouldn't have to be, but that's... the writ would have said, bring Mr. Mwenya to the High Court, so that if he can't be continued to be detained, he'll then be released. I agree. In the real world, they would probably have done some deal where he would stay in Rhodesia. But
well, I think that's right, and I mean, we're almost back to what would have happened to Rahmatullah discussion.
Well, quite. But I was just testing
yes,
in a case in which, no, perhaps it doesn't help.
I'm not sure it takes it much further. Indeed, it might take it even less far, because as you recall the facts of Mwenya, I think I'm right in saying that he wasn't actually detained at all. He was subject to, as it were, the Guzardi type only stay on the island. He had 1,500 square miles to wander in.
No, but he would then have had to be. But if he just bear with me for the moment, suppose he would have had to be brought back to the UK. The same question arises, but obviously nobody really went into that. They never got.
How do you test the legality of the detention when he's not detained?
Yes.
Well, he's only detained through force of the writ, which was my lady's point.
He's in a sense worse off. Instead of being able to roam free over many acres of Rhodesia, he's in a prison in Salisbury and then in a plane. And
yes.
And likewise, Anderson coming back from Ontario. What would have happened then? Irons in the ship.
I suppose if one thinks about it further, if that is right, and the person arrives either outside the prison gates in the foreign country or in London, and there is no power to detain, liberty being a precious thing and all of that, then do you achieve? I don't know what. I was thinking whether you achieve liberty in circumstances in which he should be imprisoned. I mean, perhaps it's back to the point that says
liberty in a place he doesn't particularly want to be. But
yes.
Well,
anyway,
I don't think we can seriously resolve these, but it shows that it's not straightforward. And I think that's all.
It does. It does.
And perhaps just to add one final element of not straightforwardness. As my lord has said, no doubt in many cases, in practice, agreements would be reached which solve problems of flying people half around the world, etc. But it's not difficult to imagine circumstances in which the court wasn't happy about the idea of such an arrangement being made. The judge who issued the writ may have all kinds of concerns about what has been going on and might actively want the body to be produced, instead of being told, oh, we came to an arrangement and we agreed he could stay where he was and he's perfectly happy.
Yes.
And then all the problems about status and right to detain,
all in their head.
I noticed that the wording of the pro forma rather cautiously says, we command that you have in the King's Bench Division of our High Court of Justice, without saying very much about how you are to have the body here.
I mean, it also raised a slightly strange prospect, which may shade into the second of the points that the Divisional Court made in its 3 dispositive reasons, which is that you would end up, in the example that you give, you would end up in the High Court, not perhaps debating the merits or otherwise of the original detention in the foreign country or the inaction of the United Kingdom in doing anything about it, but debating whether or not the practical arrangements for flying the individual to Pakistan or wherever it may be, about which the court might have some concern. You would end up having those debates on the return of the writ, which otherwise, and in all other circumstances, would look and smell like governmental decisions which would be subject to JR. My lord, so we submit that for all of those reasons, and I haven't thought to travel through the Divisional Court's judgment at any length because you've read it with care, I know, but for all of those reasons, we submit that the Divisional Court was plainly right in principle. What they sought to do, if I'm allowed grotesquely to over-summarise, but what they sought to do was to identify as key features of the cases in which the writ had issued all of the matters that we've gone through, whether you characterise them as legal requirements or jurisdictional requirements or not. And there's a careful section where they analyse all the cases, with perhaps a bit of hedging around, as my lady pointed out when my lady friend was making her submissions in Mr. Justice Jay's judgment about quite where that led. But they also then reject the idea that we're dealing with a situation in which a unilateral offer, as it was put on the basis of the submission that was made to them, created shared control, and they rejected that for all of the reasons that they gave, in particular in paragraph 91 and following. And their essential reasoning, first bit of reasoning at least, was that even the making of the offer from the foreign detainer, whether conditional or not, indicates and or was an exercise or manifestation of control by that foreign detainer over the custody. They are setting the basis for release, and the most that the Secretary of State can do, as Mr. Justice Jay put it at paragraph 91, is, quote, to react and respond to those conditions if so advised. And essentially the same point is made by Lord Justice Lewis at 107 to 108. In fact, release was contingent, as I've indicated, on the Secretary of State taking a series of steps to ensure repatriation. And that indicates, because of the nature of those steps, that indicates that this was indeed a piper calling this particular tune who is not the United Kingdom government, see judgment paragraph 92. And for all of those reasons, the case is, as the court concluded, entirely unlike O'Brien or Ramatullah, on which the argument of control rested, entirely unlike those. And we respectfully submit that there was not merely nothing wrong with, but it was obviously entirely right for the conclusion to be reached that there was in those cases, O'Brien and Ramatullah, control over a process contained in a framework that already existed. I mean, it's back to that arrangement. It's back to Lord Reed at 112 and Lord Atkinson. Why would you assume they won't comply with it? So I respectfully submit that they were right for all of those reasons. I'm sure one can confidently predict, at least, that the Divisional Court would likewise have, on the back of that reasoning, have asked exactly the same question that my Lord Justice Holroyde asked of my learned friend when she sought to distill her proposition for control into, and you remember the form of words, a set of circumstances where it's possible to say before the request that the decision by the respondent to secure release will be given effect to by the detainer. And the question that was asked was, surely you have to add into that unconditionally. And I think my learned friend was constrained at least to accept that. But the moment you get there, you're into all the problems we've been discussing. So, my Lord, my first submission is that the Divisional Court were right in principle for all the reasons they gave, some aspects of which I've gone through in submissions before you, but they were also right in fact, I submit. And that submission can be made very shortly because there is on this appeal no challenge to the findings of fact made by the Divisional Court or to their careful analysis of the facts. And indeed, those findings were, as you see from the judgment, especially paras 25 and following, and see within that little section of the judgment, especially 33 and 34, which sets out the nature of the particular steps that would need to be taken and the conditionality and so on. But they were right, as is unchallenged, in making those findings. So what will be involved is at least the following. You make the request. There would need to be travel documents issued, and the point that perhaps is to be, you're perhaps to be reminded of in relation to travel documents. If you go back into the Divisional Court's judgment, if you would, paragraph 33(1). Is the initial conclusion of the Secretary's, of the Divisional Court about the steps, as it were, that would need to be taken on the basis of the evidence and how that would work. And then if you go forward to paragraph 101.
Well, okay, are you going to defend paragraph 33(1)? It seems at the face of it inconsistent with what we established earlier, that if a British national wants to return to the British, to Britain, they have an absolute right to do so.
My Lord, there's no inconsistency. If you go to 101.
Sorry. Okay.
So position is that there isn't an obligation to issue a travel document to them in the camp. There might or might not be. The court was prepared to proceed on the basis that they would have a right or something like it. Perhaps it's better cast as unlikely to be a rational reason to refuse, even if technically a discretion, if they were to present themselves at an embassy. But they're not at the embassy. And in those circumstances, that principle doesn't operate in that way. There is no
Why
obligation.
does that make a difference whether they're at the embassy or not? They've clearly got to be in contact with a British consular official because, but in the hypothesis we've got here, where the British consular official has travelled to the camp, there can't be a rational basis for saying, I won't issue you with travel documents here. You've got to come back to the embassy, and I don't propose to take you there.
Well, my lord, it involves the additional steps additional steps that the Divisional Court identified.
Namely,
You've got to get the documents to them, and you've got to go beyond the policy. And there is no freestanding obligation to assist British nationals to return to the United Kingdom in all circumstances. So the government is allowed to have policies as to where and how you can apply and must apply for those documents if you're a British national and you've lost your passport or whatever. Perfectly lawful to have a policy to that effect. And in those circumstances, when you're dealing with someone who asserts that you have to cross the 500 miles of dangerous country to bring the documents to them, there is nothing in the right that has been identified that says you can't turn them away.
yeah,
if
I'm
you turn up
sorry,
at the
yes,
border.
I think we're at cross purposes. On the assumption that there was otherwise that an obligation, whether you reach it by a judicial review route or by a habeas corpus route, on the consular official to come to the camp and secure their release, at that point, it would be totally arbitrary to say, well, I'm going to do that, but I'm not going to bring you any travel documents because...
But it's all interwoven with that set of issues, that set of steps.
Okay, thank you.
And that seems to be the point. That's why I said rather curtly, no inconsistency, C101.
So there's a reference in 101 to that, the verification of their identities. How does that happen in practice?
Well, I'm not sure, I can't remember whether that's dealt with in evidence, but I think there is
some requirement to have
biometrics or something to make sure they are who they say they are.
Yeah. I'm not sure that's dealt with in any detail in the Divisional Court.
I don't think on the findings of fact it is, but there would no doubt be some processes, whether they involve biometric tests or not, I'm not sure, but there'd be some processes.
127 of the supplementary, which is the statement.
Sorry, I'm reminded, very grateful. 127 of the supplemental bundle, paragraph 16 of Mr. Hargreaves.
Is that Hargreaves 1 or Hargreaves 2?
2.
Hargreaves 2.
16.1.
And to save us looking it up, what does he say?
I'm just checking to see whether he says anything about check. Adult might have to attend a virtual or an in-person appointment to confirm identity. I'm sure he goes into the detail of how that gets done.
Yeah.
My lord, on that subject, my lord asked about the relevance of national security and how all that played out and how it was relevant here. And the short answer to that, I think, is that there wasn't a full or indeed any explanation of the national security reasons for refusing consular assistance in the letter. There wasn't any closed material process below, not considered necessary given the points of principle that were being argued for. But when the case started developing and when the nature of the habeas arguments became clear, and in particular when reprieve as the possibility now abandoned were brought into the picture, but also more generally, once the nature and shape of the shifting arguments on what the ingredients of habeas actually were said to be by the claimants, further evidence was put in, and Hargreaves too was put in particular, and you will have seen from the Divisional Court's judgment that most of their findings of fact of significance, or a large number of them in that section between paragraphs 25 and following, they are to do with the various steps, including the operational barriers, the security and diplomatic considerations that made reprieve unfeasible, but also that highlighted the nature of the issues that arose in trying to go through those conditions and those steps. So that's how national security, as it were, fits in as part of the evidential picture which the court was required to consider, and to which I would add there is no challenge in this court. My lord, that's the primary case, effectively. And I make some brief submissions in relation to the alternative case. So far as that is concerned, I mean, I can't quite resist saying that none of this was argued below, but none of this was argued below. But the court has read it, and I respectfully submit that it doesn't actually advance my learned friend's case at all. What to do is to set out an alternative case on the circumstances in which a respondent can be found to have constructive control. Take her concept. She takes that idea from O'Brien and Ramatullah, but in principle, it doesn't really assist to use that as a concept, because what matters are the circumstances in which you will be held to have that sort of control. No one is disputing the base proposition that you can, as it were, detain through agents.
Yes, I mean, for myself, I didn't understand it. I understood it to be that the alternative case is to be that if the kind of control that was present in this case wasn't enough, there's obviously some control in the sense that claimants will be released by AANES on request. If that's not normally enough, it should be enough in this particular case for habeas corpus to issue, for reasons which I don't think really come under the heading of control. They come under the heading of responsibility, which I queried. It sounded to me more like exceptional humanitarian stroke justice considerations.
Well, yes.
That's how that seems to me to be how the case really put.
And the answer to it is, first, there is no support for that sort of expansion in any case. You don't find any support for it in the use of the notion of constructive control, which simply begs the question, what does that mean? In O'Brien or in Ramatullah, they're each explicable on their factors that they labour through yet again. What it would actually involve doing is to say that there are, and we would say there are the well-principled and well-established boundaries and features of control that have been identified in all of the cases. And as it were, even if I can't meet that, particularly in a foreign case, I can nevertheless persuade a court to issue the writ in the face of an inability to meet that degree of control. If I persuade you that a bunch of amorphous facts that go to the merits of the case and how ghastly it all is, persuade you to do so. So to introduce a kind of quasi-interests of justice test, there being no proper basis for calling it responsibility, for reasons I'll come to in a second, but all that is a plea to is a plea to broaden the circumstances in which, despite the lack of control, the writ should issue. But the writ is a remedy of right with a correlative obligation. And it's simply not appropriate to drag in those broader considerations. It's tightly focused on a properly conceived idea of control for obvious and good reason in principle. So we respectfully submit that there is no proper basis in principle for expanding that jurisdictional base so as to step outside of those properly demarcated boundaries. And that becomes all the more...
You didn't mean to belittle it by saying, I mean, there's a real problem here, isn't there? It is, to use your word ghastly, their predicament is well, we won't bandy adjectives, but their predicament is dire. But your point simply is that that can't be a justification for using this particular legal weapon, which is not designed for this situation.
And the reason that they're using this particular legal weapon is A, because they do not want to go to judicial review because they know they can't win that, and B, because, that's contentious, but they don't want to go to judicial review for obvious reasons, but B, because they can't make a claim or a case based on true responsibility under any of the international conventions that would sound in domestic law. And no doubt my learned friend found it attractive to present this not as being a broad interest of justice thing, which would open the door to almost anything, but to present it as being a state responsibility thing, because that would then tie a bit closer at least to the notion of control. But the truth of it is that the responsibility idea doesn't get off the ground in principle. It doesn't get off the ground in principle because there is no jurisdictional basis being essential to the application of the substantive articles under the ECHR or under the ICCPR or anything else. The responsibility for the conditions is that of AANES or Syria. It's not the responsibility of the United Kingdom. There is none of these people are within the jurisdiction of the United Kingdom, as does not appear to be contested. So that is not a proper basis. Take it out a stage further, even assuming there would still be a particular problem for these individuals because they go into this territory voluntarily. They're not put there by the United Kingdom. But the United Kingdom has no responsibility for those conditions, so that can't assist. And so all that is in truth left is the plea that says we are the only state who is responsible for the non-release. But the answer to that is that's obviously incorrect. It is back to control again. And the people who are detaining these individuals are AANES. So to dress up interests of justice or state responsibility on the basis that we're the only people detaining and they can't deport, it doesn't go anywhere. It's just a question. It's back to the question of control. So the only thing you're really left with is the plea to conditions for which we are not responsible, and on which the interests of justice, as against the United Kingdom in the domestic courts, would not bite.
Or you say in the international courts.
Or in the international courts as against the United Kingdom.
Yeah, quite.
Yes. I mean, but it wouldn't. I mean, that would be a much more difficult plea because without the force of the Human Rights Act, you'd be left with unincorporated international conventions and all sorts of J.H. Rayner problems. So really, I mean, one understands why she makes the merits point, but calling it responsibility is a misnomer, and it is not something for which the United Kingdom is responsible. So we submit, and that perhaps grounds the non-objection, as it were, to the court taking account of that skeleton argument on that this case is either a redressing of the control point, see previous submissions, or it asserts a responsibility for things for which the United Kingdom is plainly not responsible. Well, those are my submissions.
Yes, thank you very much, David. No, thank you. Yes, Ms. Carter.
My Lords, going back to where James set off this morning, where he took the court through the authorities, or a series of passages in particular from Ramatullah and O'Brien. And no doubt the court will have noted that those passages were also ones to which I took the court, something which the court might have thought was striking. And the question is why? Why did we both go there? And the answer to that is because none of those passages, in and of themselves, contain all the elements of control for which Sir James insists as being necessary elements, whether as jurisdictional elements or otherwise. And as he conceded in relation to a question from Lord Justice Holroyde, he has to look elsewhere at the background facts. So the position remains that this court has to decide whether or not, in addition to what is clearly stated in those passages, is simply a factual question of whether or not, as we've characterised it, the respondent has control in the sense of the power to bring about the end of detention by reason of a request that the circumstances demonstrate will be responded to positively, either by reason of an obligation or by reason of a bilateral agreement or by reason, as arises in this case, of a voluntary offer, together with all the other circumstances we have identified, which show that such a request will be acceded to, given the necessary power. Is that enough, the court has to decide, or is there something more that is necessary? And in our submission, that is all that the cases so far have decided, and that is what distinguishes the cases of Ramatullah, O'Brien, and Bernardo from persuasion cases, the Abbasi cases, where what is missing is not prior detention, is not some sort of legal obligation to seek the release, whether that be an obligation that arises in international or otherwise, but what is missing in those cases are the circumstances which mean one can say a request will be treated as giving rise to an obligation to release. That's the distinction. And we maintain that that is what the authorities lay down. On conditions and the imposition of a condition, well, you have our case, that our reformulated case, as Sir James pointed out, that no, there will not be control where the conditions are imposed unilaterally. What is distinct and unique about this case is that the condition is simply a condition which must be, in any event, given effect in order to comply with the writ.
But is that quite right?
Well, that's what I wanted to move on to explore that.
Well, the writ, okay, but let me just ask you this. The writ obviously says produce the body in the Royal Courts of Justice. But that is simply a mechanism to ensure an examination of the lawfulness of the detention, and that if it is found not to be lawful, the court can effect release by, as it were, striking off the shackles there and then. But the essence is the ending of the putatively unlawful detention. And if that detention has in fact come to an end,
You don't need to bring them to court.
You don't need to bring them back to the UK.
No, but we're focusing at the moment on the condition and whether or not there is anything in that condition that means it falls on the side of that which entails that the respondent does not have control in the necessary sense. Give me £1 million, give me £10, whatever it is, whatever conditions are imposed, or it is entirely consistent with the nature of the habeas corpus jurisdiction. And this condition is so consistent. The fact that after the writ has been issued and in attempting to execute its requirements, the respondent will find him or herself in a position where either he just decides to release there and then, having secured the release from the camp, and therefore go back to court and say, well, I don't need to, in any sense, justify the legality of detention because I've released. That's a matter for the respondent. That's a matter within their choice. And what that actually does is it undermines the respondent's own arguments that to take the course we are submitting in law is required steps into territory that is properly for the Secretary of State, because the Secretary of State retains a significant measure of control over that territory. That said, it has to be recognised that the habeas jurisdiction does necessarily, in an international context, which requires action on the part of the Secretary of State in the international plane to give effect to a writ, it does trespass into what otherwise would simply be the territory of the government in the conduct of international relations. Hence, in Ramatullah, the protestations that if you issue this writ, you're going to require us to have to ask the Americans to release. And that's a matter of diplomacy and something which is for us. So, yes, the writ is extremely powerful. Yes, the writ does trespass on that territory. And no, in this case, the writ's trespass onto that territory is not necessarily of far greater effect than it would be in other cases. I mean, had Mr. Ramatullah been released, had the Americans acceded to that request, then there might have been all sorts of implications in the sphere of international relations for the Secretary of State in order to give effect to that. We don't know, but the point is the writ compelled those steps to be taken. And in the case of Mr. O'Brien, he was brought back to court in England. Now, steps had to be taken to ensure that was the case. It might have been a little bit more straightforward because of where Ireland was, a free state in relation to Britain, but those steps nonetheless needed to be taken. So, the fact that there is this condition, which is in any event something that is an aspect of the writ, does not take this case, or rather compel the interpretation that Sir James calls for in relation to the authorities. Can I turn to legality? The legality of the detention, and that rather thorny question, which isn't resolved and which is slightly fudged in Ramatullah, of the time at which, or the detention with respect to which, the question of legality is to be determined on the return. In our submission, it is the legality of the detention in the place where the person is being detained at the time the writ is being sought. That's the only sensible way in which this can be understood, because the whole basis upon which the writ issues is that the respondent is responsible for that detention in some way, shape.
Yes, but the only purpose of habeas corpus is to obtain release.
Yes. So
all it is.
Yes.
And you have to bring a separate claim for wrongful imprisonment.
Oh, absolutely. But the part and parcel of the process of obtaining release is establishing the illegality of the detention. Now, the way it works is that the applicant doesn't have to establish the illegality. A prima facie case is established. The defendant, the respondent, has to justify the detention. Now, in a situation such as this, where the detention is by a foreign body, not in this instance a state, but in Rahmatullah it was a state, and then concerns arise in relation to...
Well, in Rahmatullah, the detention was never, in the relevant sense, by the US, because the UK had transferred to the US on terms they could have it back whenever they liked.
Oh, but
So the relevant control...
the control, but the detention and the basis for detention was US detention in Bagram. There was control in that there was the means to ask for that detention to cease in certain circumstances. But the basis of detention and the depended upon whether or not there were conditions that could justify the United States in holding Mr. Rahmatullah in Bagram at the time that he was bringing the application.
That's just what in Rahmatullah Lord Kerr said the court wouldn't be able to go into.
Well, he slightly fudges the issue, but in our submission, one can go into these questions, and there are two answers to it. Firstly, Rahmatullah was decided before Belhaj, and Belhaj developed the law in relation to foreign act of state very, very considerably, such that detention such as this by a foreign power, where what is alleged is that the detention breaches fundamental rights of the detainees, is something that the courts are perfectly entitled to look at and to address and to determine. Yes, Rahmatullah was an appellant in that case.
I have no idea what you mean.
So Rahmatullah was bringing a civil claim. I represented Mr. Rahmatullah in those proceedings that
Which
became
proceedings?
linked up with Belhaj.
Which proceedings?
So they were
Which proceedings?
the Belhaj.
Belhaj, sorry.
The Belhaj proceedings. So Belhaj was a case which heard a challenge by Mr. Belhaj in one set of civil proceedings and a challenge by Mr. Rahmatullah and others in another set of proceedings. And Mr. Rahmatullah was bringing a civil claim against the MOD, alleging responsibility on the part of, alleging unlawful detention, including in relation to the US's role in detaining him. And one of the arguments brought against Mr. Rahmatullah was that this was forbidden territory, the case should be struck out because of the doctrine of foreign act of state, and that failed. And in the course of that, the judgment that the Supreme Court gave in Rahmatullah, it was established. I'm going to hopefully give the court citations of the relevant passages.
Well, have we got Belhaj in our...
We have got Belhaj, yes.
Tab 17.
Tab 17. And if the court reads the head note, I think, we can get what we need for current purposes from the head note.
Which bit of it, though?
So if you read the holding, not state immunity, that's the first holding, and then the second holding in the head note.
Okay.
So, where the allegations are of illegality, such as complicity in torture, unlawful detention and rendition, then the court is not precluded from pronouncing upon the legality of the actions of a foreign state actor. So, things have moved on since Rahmatullah, but in any event, should the Secretary of State have concerns about the court trespassing into this territory then the option is there for the Secretary of State simply not to seek to defend the legality of detention. And that's the straightforward way through. So, writ is issued, the Secretary of State does not on the return seek to defend the legality of the detention, and the individual...
This is all very artificial, isn't it? Because the reality is that once the claimants have been released from the camp, and, which is what you say would have to happen, brought back to this country, whatever power there may have been to detain them there is no longer relevant. Are you seriously saying that the UK government would, in circumstances where the release had been effected, still have to justify a detention which was no longer being maintained?
Well, the way to go about it, if the UK wanted to justify the detention, would be to say, this is not a case at all where the writ should run because the detention is lawful. Let's not even get to the point of looking at control. The detention is lawful. You cannot issue the writ at all because there is no question of the illegality of the detention to look at. So you don't get off first base. That's one suitable way around that problem.
But why would the Secretary of State be seeking to suggest that the detention of the respondents by AANES is lawful? Sorry, am I being slow? I'm just not following this.
Well, because the whole purpose of the writ is to secure the end of an unlawful detention. If in fact the detention is not unlawful, if the Secretary of State is satisfied that the detention is not unlawful,
I suppose the Secretary of State believes that it is unlawful.
Yeah.
yes. Well, if the Secretary of State believes it is unlawful, then the Secretary of State has a choice open to him. He simply doesn't defend the issue of the writ at either stage, either initially or on its return, on the basis that the detention is lawful. It's as simple as that. And then if he has control, as a matter of fact, the writ will issue and he can simply secure the release, not have to bring the individual back before the court. And
You're saying they do have to bring the individual back before the court?
No. I've said that the writ requires that, but as we've already just addressed, there are myriad ways in which, once the writ is issued, the
I see. So
Secretary can
it's
go
your
about
case
his
that it would be
business.
lawful. It's not what you would want to happen, but it would be perfectly lawful for the Secretary of State, subject to anything may have agreed, which has nothing to do with you and not enforceable by you, to AANES, to go and secure the release and simply abandon her outside the gates.
Yes, then that may give rise to issues, for example, under Article 3 of the Convention, because there may be jurisdiction there, extraterritorial jurisdiction, because the Secretary of State has control over the body at the point that the body is handed over to them, and therefore
All right,
what the
suppose
Secretary of State then
the
does.
Secretary of State takes her over the border and puts her down in
A safe country.
in a nice hotel in a neighbouring state, so there's no Article 3 issue arises.
Fine, that would be fine. That would be fine.
And then when the return turns up, when the return date comes, they turn up in court and say, we're not justifying the detention, we haven't brought her here because we've released her.
We've released her, and here's the evidence that we've released her.
Sorry, Mr. Kaufman, if I'm being very slow. What's happened to the obligation to repatriate in all this?
Well, the obligation to repatriate is one which was the basis and the condition upon which detention, there was an agreement on the part of the AANES to release.
Yes, but that would be unenforceable by
And it's
you.
not enforceable. It's simply not enforceable. They will have gone on the basis that they will comply with that obligation, and then in the end, for whatever reasons, they decide that they're not going to do that.
Right.
But she's not. She's not on Lord Justice Underhill's hypothesis set down in northeastern Syria because of the reasons we've just addressed. So I then turn to our secondary case and just clarify, particularly for my Lord Justice Underhill's purposes, what, when we talk about the alternative case being based upon power and responsibility, we mean? We do mean, contrary to what my Lord understood, that control comprises, on our alternative case, both the power to release, in the sense that we have described it, that de facto power, and the responsibility to do so. And what we submit is that the instances that there have been to date, in the O'Brien case, Ramatullah, are instances of where responsibility as well as power are established. And the responsibility can arise because of having had original custody and having the power or the duty to secure the return. And in our submission, the very, very different facts of this case, and we accept they're very different, nonetheless gives rise to responsibility of a kind that means this court should require the Secretary of State to exercise the de facto power he has by virtue of the offer from the AANES. And perhaps lying at the heart of what we mean by responsibility is, forget anything legal, this is a factual question and you have to look at all the circumstances, but there is, in those cases, as there is in this case, a causative proximity to the current detention. And that, in our submission, is critical.
Can I just explore that? In what sense is the current detention causally connected with anything that the Secretary of State has done? Or are you simply saying there's causative proximity because the Secretary of State, if the Secretary of State chose to comply with the condition, could cause AANES to release?
Yes, because the Secretary of State is, in reality, the only body capable of securing the release, so has the power to do so, is in reality the only body capable of doing so.
Right, so there's no causal connection between the Secretary of State and the original act of detention?
No, and that's precisely...
I just wanted to be clear about that.
Yes, our case is that one should not set down any rigid requirements for the reasons that we addressed before, that there has to have been a pre-existing responsibility. Responsibility can arise in myriad circumstances.
Help me with this, if you would. In what circumstances could there be a sufficient power to bring to an end what is ex hypothesi unlawful detention and no responsibility for doing so? Just wondering what it adds to the... If the necessary control is it, if you're in control of the unlawful detention of the subject, you've got to exercise that power, haven't you?
No, so on this case...
Well, what are the circumstances in which you can say, yes, all right, I am in control of this detention, and yes, it is unlawful, but I'm not under any duty to do anything about it?
So one example would be, on this alternative case, would be that you have an authority, a state, who simply offers to send a particular individual who's not a British citizen, for example, to the United Kingdom, or to release the United Kingdom, should the United Kingdom ask for their release. Now, we're working on the premise that that is not sufficient. That's our primary case. That is not sufficient. So what we have here is, if that's not sufficient, what is there in addition? And what there is in addition are all the factors that I highlighted earlier in my opening submissions that give rise to responsibility and to the proximity, causal proximity. So the fact that they are...
You are slipping about, rather. I thought you had focused, at this stage of the argument anyway, not on the direness of the conditions, which we all accept, but on the fact that what you call causative proximity which means that you're the only person who can do anything
No,
about it.
and that's not alone. No, I'm sorry. All those factors give rise in my submission to a measure of causative proximity that establishes responsibility. So the fact that they're British citizens, the fact that they are not being permitted back for reasons of national security, which the Secretary of State is unable and has been unable.
But hang on, that's not nothing to do with release, has it? That's not nothing to do with habeas corpus. But
But
habeas
it
corpus,
has got everything to do with why they won't be released. It has everything to do with why the power won't be exercised. So the Secretary of State is doing through the back door something which the Secretary of State cannot do through the front door. It has everything to do with why they are not being released, where the Secretary of State has the power to do so.
yes, it doesn't sound to me much like responsibility. That sounds to me like a classic judicial review, illegitimate motive.
Well, it may also be that, but in our submission, these factors cumulatively establish responsibility for the detention, the continuing, the ongoing, and the current detention. My lords, my lady, unless there is anything further I can help the court with.
No, thank you very much. Thank you. Well, thank you both and the large teams behind you for very some interesting submissions on what's obviously a very troubling case. We will be taking time, hopefully little time as we can, and it will take some time, to reach our conclusions. We will, in the usual way, circulate judgments in draft to council to enable them to agree consequential matters. If they can't agree, to produce short written submissions so that we can produce a final order at the time of the hand down of the judgment. Also to help us with typographical and other minor factual errors. As you are aware, circulation is only for very limited purposes, and any onward circulation by counsel or solicitors should only be to those who need to see the drafts for those very limited purposes. All the guidance is there in the Counsel General of Wales case, which you know very well. Thank you again.